This is Duke University.
Hey again, everybody. Thanks for being here for our afternoon panel. As you know, this is our third and final panel of the day. And to moderate, we have our very own Professor Margaret Lemos, who joined the Duke Law faculty in 2011 from the Benjamin N. Cardozo School of Law. And we're both happy to have her here at Duke generally, and especially to be here today to moderate. She's a scholar of constitutional law, legal institutions, and procedure. Her scholarship focuses on institutions of law, interpretation, and enforcement, and their effects on substantive rights. In particular, she writes in 4 related fields: administrative law, federalism, statutory interpretation, and civil procedure. Her articles have been published in the Supreme Court Review, as well as in the NYU, Texas, Minnesota, and Vanderbilt Law Reviews. Prior to joining the faculty at Cardozo, she was a Furman Fellow and Program Coordinator at NYU, a Bristow Fellow in the Office of the Solicitor General, and a law clerk for Judge Kermit Lipez on the U.S. Court of Appeals for the First Circuit and for U.S. Supreme Court Justice John Paul Stevens. Thank you again for helping us today.
My pleasure. So I'm so happy to be part of this great panel, and I will briefly introduce our panelists so that they can get down to business and we can hear about their great papers. So first is Professor Stavros Gadinis of the UC Berkeley School of Law. Professor Gadinis has a law degree from the Aristotle University in Greece, as well as an SJD degree from Harvard and an LLM from Cambridge. Before entering academia, he practiced corporate law for several years in Europe. And his academic work now draws from that. He focuses on securities regulation and international business transactions, and in particular, their relationship between the financial industry and government regulations. And consistent with the paper that he's talking about today, his work is intent on cracking open the black box of administrative agencies to see the different sorts of people lurking inside, and particularly drawing out differences between agency officials and political appointees. Next down our panel is Professor Emily Hammond Meazell, yeah. Sorry, who's at the University of Oklahoma College of Law. Professor Meazell graduated summa cum laude from the University of Georgia School of Law and then went on to clerk for Judge Richard Story of the Northern District of Georgia, and then to practice law in Atlanta for several years before moving into academia. Her academic work focuses on administrative law, law and science, risk regulation, and energy law and water law, topics which allow her to draw on her really interesting background as a civil engineer. And her most recent article, recent at least before the piece she's presenting here today, deals with the dialogic relationship between courts and agencies and is forthcoming in the Columbia Law Review. Last but not least is Professor Ronald Krotoszynski of the University of Alabama School of Law. Professor Krotoszynski got his JD here at Duke, yay! And then went on to clerk for Judge Frank Johnson of the 11th Circuit and to work at Covington and Burling in DC. Before ending up at the University of Alabama School of Law, Professor Krotoszynski has worked at the Indiana University School of Law in Indianapolis and Washington and Lee University. And he now is at Alabama, where he writes about constitutional law, including First Amendment issues and related questions of telecommunications law and policy, as well as the structural issues of separation of powers and federalism that he will be talking about today. So with no further ado, let me turn this over to our panelists, each of whom will speak for about 10 to 15 minutes, a time limit that I will enforce with an iron hand. And then we will have lots of time for questions and discussion.
Well, thanks very much, Professor Lemos, for that great introduction. For those of you who were not here in the early panel, the work that I'm presenting today argues that there was a conventional paradigm where financial regulation was mostly at the hands of independent agencies, and what I'm arguing is that a lot of new powers actually go to elected politicians, so after the 2008 reforms. And this was the general pattern that we're seeing. A lot of them, in many instances, the powers of political bodies have increased after the 2008 reforms. So as I mentioned, in this panel, I want to focus more on what are the qualitative characteristics of these reforms. Now, there are three key characteristics of these new powers. First, that there are direct grants of authority to politicians. So politicians are asked upon to make a specific decision rather than appoint or remove agency officials, which was the norm before. They expand on both emergency situations, which was what happened in the 2008 crisis, but also in the regular ongoing supervision over the financial industry at times where there's no crisis lurking. And there's no significant redesign of the regulatory structure. One of the arguments for why the financial crisis happened was that we had a cacophony of regulation. We had many different regulators with different powers, and none of them kept an eye on the system overall. Where we don't see these, we don't see consolidations of regulators, but what we see is new bodies added on top of existing ones, sometimes with a goal of trying to create a better sense of what's happening all over the financial system. I'll explain all this in a minute. So what this chart shows you is what kinds of new powers have been added in 2010 in each of the countries included in my study. With blue is the regular power to appoint or fire agency officials. And you see if you are in 2007, you see much more blue. There are instances where there are direct powers are less compared to the regular removal and appointment powers. If you move to 2010, the increase, which happens across the board, is mostly in direct powers. Now, I have also highlighted in red the power of politicians to grant loans directly to failing financial institutions, because that's a very important issue. It's the heart of the bailout question, right? Whether to finance an institution that fails. And also you see that some countries limit the scope of judicial review of these decisions in yellow. So that becomes more clear in this chart, which shows only the new powers added after the reforms. And you see that very few countries actually tinkered with the appointment and fire and removal question. And most of the new powers added have to do with direct calls on politicians to make decisions themselves. And of course, all the cases where loans are granted, where there are new powers to grant loans to failing financial institutions, all these instances go to politicians. So to connect that a bit with what Professor Meazell is going to be talking about, all the red and green powers are instances where you have multiple agencies or multiple decision makers working together. And it's only the blue powers where you have movement in the traditional, let's say, model or distinction between the executive and independent agencies axis. And the rest of it is an attempt to overlay decision makers one upon the other. Now, next I'm going to be talking about the various issue areas and where you see most reforms. So in prudential authority, that's the regular power to supervise, make key decisions about who enters, who leaves the financial industry. What you see is that politicians' powers in approving who gets a banking license have increased. So there are more countries that now require the Secretary of the Treasury to approve whether a new bank can be established or not. Now, The next chart over there shows the increase in resolution powers, so whether the Secretary of the Treasury or the Finance Ministry has to agree in order to put a bank into liquidation, bankruptcy, or any sort of resolution procedure. And you see the huge increase in the requirement for consent, and also that, as I was saying before, they must also approve loans, so the extent to which they finance the failing institution. And you also see that they have their hands in the column right next to it, which says process, that in many cases the finance minister or the Secretary of the Treasury actually handles the whole liquidation process, or one of their appointees. Now, where you don't see a lot of move is in supervisory authority. These are kind of low-level regulatory decisions that get banks, kind of that happen in the bank's regular cycle, business cycle. For example, credit card regulation or loan regulation, mortgages regulation. You don't see any increase in politicians' powers over these kind of more mundane, let's say, issues. And in deposit insurance, you see some increase, but kind of a moderate one. Basically, there are some countries that didn't have deposit insurance before the crisis and introduced it after the crisis. And when they introduced it, they also gave the powers to politicians. Now, how much agency consolidation has been going on? As I was saying, this fragmentation of regulatory authority between multiple regulators was thought to be one of the reasons for the 2008 crisis. So perhaps one would expect that if we're enacting regulatory reforms trying to address the problems of the crisis, we would perhaps consolidate some regulators. Well, there was some agency consolidation, but it was limited. There was a redesign of regulatory agencies in France and in Switzerland, where there was mostly a switch of powers between the Swiss National Bank and the Swiss regulator, and also insurance regulators merged with the securities and banking supervisor. But that's as much agency consolidation that we had around the world. What you had instead was a host of new agencies where politicians gained renewed influence. So in Germany, there's a new board in BaFin. It used to be, that's a very funny story, because it used to be that BaFin was, it's the German banking regulator, and it was a guy who was appointed for life. And then they weren't very happy with how he performed, so now they created a board for him. So now he's one of 5. And he kind of lost the majority. And it's, there's no direct removal power. So the German chancellor cannot fire the other 4 members of the board, but she can redeploy them somewhere else in the administrative structure. So that's how they solved this issue there. And in France, when they redesigned the regulatory agency, you had a majority of new members being directly appointed and removed by the finance ministry, which was not the case in the old agencies, the 3 that preceded ACP. Now, in Spain, there's a special fund for bailing out banks, because they had a lot of bank failures related to real estate, to a housing bubble, and that's completely under the control of the Treasury. And of course, in the US, you have the FSOC and the Orderly Liquidation Authority, and I'll talk about that in greater detail in a moment. Now, what you also see, so the biggest trend that you see, as I showed in the previous charts, is that there's greater cooperation between independent agencies and politicians. So there are co-decision procedures in various issues introduced in 10 out of the 15 countries in the data set. So US, UK, Germany, France, Spain, Belgium, Ireland, Italy, Canada, and Japan, they all have this co-decision procedure where the independent agencies have to, and the Treasury or the Finance Ministry have to agree in order to undertake action. So here is how things look in the US, for whomever is looking for, I don't know, a 30-second summary of Dodd-Frank. There is a new agency, the Financial Stability Oversight Council. This has captured public imagination because it's a council of regulators. There are about 10 regulators, including the Fed, the FDIC, the ACC, that they all see together. So it's a constellation of regulatory power with, however, very little actual powers to implement actual reforms. Their main goal is to kind of have an overview and coordinate their separate regulatory agendas. And that's chaired by the Treasury, and the Treasury sets the agenda for the FSOC meetings. However, the FSOC has one power, which is a real power, and that's they get to decide which non-bank financial companies are going to be subject to Fed supervision. So which financial institutions who were not subject to supervision by the Federal Reserve are now going to be pushed into the Federal Reserve. And in order to reach that decision, the 2/3 of the regulators participating in FSOC have to agree, but the Secretary of the Treasury has a veto right. So they have to have her consent in the end. Now, the Orderly Liquidation Authority, that's how the arrangements, the institutional arrangements for deciding that a financial company, which includes bank holding companies, so Fed-supervised banks, are in default. So the rules there are that in order to determine that such a financial company is in default, 2/3 of the Fed board must agree that this is the situation in that bank. 2/3 of the FDIC's board must agree that that's the situation. And the Secretary of the Treasury has to give her consent. So without the Treasury, nothing moves, and it's actually the Treasury that has to take the advantage, has to issue the action, will represent the regulators in court. All that is led by the Treasury. And finally, now once this financial company gets into liquidation, the regulatory agency who runs the show is the FDIC, but the FDIC has no money of its own, so it has to go to the Treasury and ask for money. So the basic function of the bailout, which is getting new money to the financial institution, that's completely controlled by the Fed, and it's sole authority, right? No court decision here. Okay, so that's the overview of the Dodd-Frank Act. Now, just let me conclude with the main points I touched upon both in this presentation and my earlier one. So in the pre-crisis world, we had a conventional paradigm of agency independence in finance regulation. What I show is that this paradigm is under attack. There are new powers created, and these powers went mostly to elected politicians or their appointees, and these new powers have three characteristics. They include both emergency operations and the ongoing supervision of the banks. They are direct grants of authority, where politicians have their own decision-making powers. And there's no significant redesign of the regulatory structure in most countries, but instead you have these new organs that are councils of regulators with politicians at the helm and politicians holding significant decision-making powers there. Thanks very much. I'm looking forward to your questions.
Well, good afternoon. After hearing everybody's presentations so far, I have a whole list of notes that I think basically write what I have to say for me, just relying on everything I've heard already today, which is terrific. The context of the paper that I submitted for this symposium arises from the Yucca Mountain Project and the dispute surrounding that. And just for those who maybe aren't familiar, this is the congressionally designated repository for the nation's high-level waste, which is the spent nuclear fuel that comes from commercial nuclear power generation. And I really got interested in this topic because I've had the privilege to work with a number of the scientists and engineers who've worked on that project. And I think that it is a fertile area to think about lessons for administrative law generally. All kinds of issues there involving how do we engage stakeholders in decision-making, how do we use formal procedures to achieve regulatory ends, and then there are also lessons for institutional design, particularly where multiple agencies share responsibility for implementing a statutory scheme. And that final point is really the focus of this essay. I'm going to use the features of the Yucca Mountain controversy to kind of frame things, but I try to develop some more broadly applicable ideas because I think administrative law is moving in this direction. One of the things I was thrilled to read Stavros' paper because I think it suggests other areas where we could have conflicts between agencies, particularly where one has a veto power or a consent requirement over another. I think it raises some very interesting questions. So from a descriptive perspective, what I'm really looking at here is the idea that our traditional reasons for deference to agencies are sometimes split apart when we have multiple agencies making decisions. And then more normatively, I think about how courts might resolve those types of conflicts. And here, I do push back on what I also agree with Jody has become an important part of the administrative law story, which is this political or presidential control idea that Catherine has written about. And I really come back to the idea that congressional intent ought to be the compass for resolving these types of disputes. And then I suggest some features of institutional design that might be useful in figuring out what that intent is. So I'll give you a little bit more context of the Yucca Mountain controversy, discuss a little bit the theories of deference. I get to rely on what Stavros has already said about independent agencies and how those work. And then I'll develop some of my ideas about this congressional control approach. So the context. In 1987, Congress amended our Nuclear Waste Policy Act to designate Yucca Mountain as the only site for the nation's nuclear waste repository. And it gave responsibility for doing that to 3 agencies. First of all, the Department of Energy is responsible for doing the geological characterization of the site, of making a safety case, of convincing other agencies that it's a safe place to operate, and then to construct and operate the facility. The Nuclear Regulatory Commission is a licensing agency here. So it has to develop the performance criteria for the repository. It has to develop environmental requirements in consultation with the EPA, so there's a third agency here that I do put aside for this paper. And then it has to determine, on review of those license applications, whether the licensing criteria are met. Now, obviously, this is an extremely controversial statute for a lot of reasons, lots of litigation in this context. But in 2008, the Department of Energy submitted its construction license application and its safety report, and things looked set to proceed with the NRC's consideration of the application. Well, in 2008, President Obama then was campaigning, and he made a promise to Nevada and Senate Majority Leader Harry Reid, who is also from Nevada, that if elected, he would shut down Yucca Mountain. So we're talking about the influence of politics here and blood sport. This is very much a poster child for that kind of context. We know that we had presidential control in this particular situation, and we know that politics was very thickly involved. So when President Obama was elected, what did he do? Well, he directed the Department of Energy to move to withdraw its construction license application. Now, this motion had to be filed before the Atomic Safety and Licensing Board, which is a component of the NRC, and that board denied the motion. Now, I think I should emphasize that the Department of Energy's rationale, why it should be allowed to withdraw the license, was not based on safety, was not based on technical considerations. And the DOE was very clear about this. It said, we have nothing to say about our science and our technology, but we do think that this is an unworkable approach. All right. The licensing board said, your statutory mandate does not give you the authority to withdraw on that basis. The licensing board denied the motion, and we sort of have this now, what I call this deference dilemma. If a court is going to look at this or get involved, how is it going to decide between one agency that's claiming the authority of the statutory mandate and another agency that's claiming the authority of presidential control? And this is where I'll take a step back and think about those theories of deference a little bit more. The first one, of course, we've already heard about today, which is the idea of political control or presidential control. And just very briefly, this is generally grounded in the idea that the president has the duty to take care that the laws are faithfully executed, and the idea that the president provides that political accountability, at least if we're talking about the relationship between a court and an agency. The idea that the administrative agency is a more politically accountable body justifies, at least theoretically, at least some deference from the courts. By contrast, the expertise model of deference was especially prevalent during the New Deal. It arose with this idea that administrators are technocrats who can make science-driven decisions that are superior to anything that the courts could do. And so even though we don't really expect agencies to behave quite that way anymore, it's still a ubiquitous rationale in judicial decisions, at least for why courts will not substitute their judgments for those of agencies. There's still this idea of comparative institutional competence with respect to science and technology that persists. Now, these often work in tandem. So if we think about the Chevron case itself, right, we're thinking about the EPA, it's deciding how to interpret this bubble standard and stationary sources. If you have an agency that's using the contours of scientific uncertainty to sort of develop a reasonable spectrum of policy choices, given that scientific uncertainty, then political control helps justify the idea that the agency can choose from amongst a spectrum of reasonable decisions, right? So you kind of let the scientific information give you your spectrum, and then your choice along that spectrum would be rationalized on political accountability. But what if those rationales compete? And here in the paper, I do spend some time on independent agencies, which I think Stavros summarized very well in terms of particularly the theory for what they do with respect to both expertise and policy. And so I would just like to emphasize here that many of the structural features of independent agencies are designed to separate expertise from politics. There's this idea that independent agencies do regulate in very narrow spectrums, and so they gain a familiarity with their regulated field that perhaps more broad executive agencies wouldn't. They're headed by these multi-member commissions that can only hold a bare majority of any political party. They have staggered terms. They're removable only for cause. And so there is this idea that when Congress delegates authority to an independent agency, it's trying to shield that agency somewhat from the president. Partly this protects congressional desires, but partly it helps with the neutrality of what the independent agencies are doing and perhaps provides some insulation from interest group capture. And as I mentioned in the paper, the history of the Nuclear Regulatory Commission tracks a lot of this theory very well. There's a lot of indications in the legislative history and contemporaneous writings going back to when it was the Atomic Energy Commission very early on, that with something so important and so powerful as nuclear energy, remember, this is coming off of World War II and the world seeing the power of what splitting an atom can do. First of all, that we wanted to have a body of individuals responsible for this power, a commission, not just an independent person. And there was also this concern that we didn't want to have it too political. We wanted to develop that expertise and have expertise drive what the agency did, as opposed to politics so much. So if we step back to the Yucca context, you can see how problems have arisen here. We have the presidentially controlled Department of Energy moving to withdraw its license application, And the NRC, the independent agency, maybe has at least a superior claim to expertise as the licensing agency, is denying the motion. So what should happen here? This issue was prematurely taken to the DC Circuit. It wasn't ripe because at that point, the board's decision to withdraw or to reject the motion to withdraw had not been fully appealed to the full commission. But Judge Kavanaugh issued an interesting concurring opinion there. He strongly took issue with the idea that the NRC could have the final word over the president. He argued that independent agencies are constitutionally suspect because they conflict with that presidential ability to execute the laws because the president can't remove them. We might hear a little bit more about this from Ron as well as we get into the next paper. But as I look at this opinion and I think about, well, how should we deal with conflicting claims to deference by agencies, I think that his opinion completely overlooked the role of Congress in all of this. Congress set up this scheme. It purposefully put these agencies in tension, and it also said what it wanted to happen. And so I think as we look at this, as we step back a little bit and think about administrative law more generally, this is where I push back on the presidential control model, at least the very strong form of it, and I say, well, wait a minute. One of the fundamental things about administrative law is that we're talking about an exercise of delegated authority. We're talking about fidelity to the statute, as Tom mentioned earlier and as we heard from some of the other speakers. And so if we're thinking about that, then I think in considering this deference dilemma, we need to go back to what is the statutory authority and how are the agencies behaving within that. So quickly, I will mention a few things that I worked through, and again, this is similar to some of our other speakers, putting some things on the table. I don't know that this list of ideas is exclusive, and there are problems with some of them. But I think hopefully it's helpful in thinking about what we might do, especially with these increasingly complex types of delegations. And this really comes to the issue of, well, how are we going to determine congressional intent? Because Congress doesn't normally say what should happen if the NRC doesn't let the DOE do what it wants. All we have is the statute that was enacted in the first place. And so I think that looking for factors that tip the balance in terms of pointing a court toward the proper agency for giving deference could be helpful here. And so I mentioned three factors. Expertise is one of them. Features of independence is another. And then I also look at the form and formality of agency action. So starting with expertise, I actually discussed this one with some reluctance. I have previously written some work that's quite wary of judicial review that would give too much deference on the basis of an agency's claims to expertise. But here I think it's all right because this is just for identifying which agency ought to get some deference. This doesn't necessarily say it should be more deference than usual. But to the extent we can say that expertise does provide some sort of a check on policy, kind of like what Jody mentioned earlier this morning, it defines the spectrum of reasonableness. It helps temper a judicial inclination to decide based on policy preferences. And we know that expert reasoning is subject to hard look review, so there are some checks. Regardless of how you feel about it, I think there are some checks there as well. So I think that this extra legitimizing function of expertise provides perhaps some justification for giving deference to an agency that Congress has given specific expertise to. I also look at features of independence for the reasons that I mentioned earlier and some of the reasons you heard from Stavros. I think that if Congress devises a scheme where an agency, an independent agency, has authority over an executive agency, that ought to matter. Now, of course, we see some of that flip-flopped with Dodd-Frank, but if we ascribe to Congress an intent to protect some agencies from political winds more than others, like the NRC, then it seems reasonable to favor the judgment of an independent agency in a competing deference situation. So that's another potential factor. And then finally, I look at the form and formality of agency actions. When Congress has specified adjudication and specifically formal procedures, and I'm talking about sections 556, 557 of the APA, I think that also signals a preference for some independence and some insulation from political control. We know that we expect our adjudicators to be neutral, so there's a due process component to what happens there. We know that if we have formal procedures, those are going to be insulated from OIRA review. They are also subject to the closed record requirement that we touched on earlier. And so this also furthers legitimacy because closed records make oversight easier. Again, picking up on some of our issues from this morning. So I think looking at those could also be useful. Now, putting this into the Yucca Mountain context, these all favor the NRC's approach. We know that NRC has the licensing expertise. We know that it's independent. And, by the way, this is formal adjudication when we're talking about these licensing decisions. I do have an interesting postscript, though, to how all of this worked. And I think it shows that sometimes theory doesn't line up with reality quite as well as we would like to. The NRC has now halted the project, too. The chairman is an Obama appointee, and he unilaterally decided to halt the project. Now, there's quite a bit of debate. There's all kinds of potential lawsuits brewing over his authority to have done that. He basically said that it was a purely administrative move and not something that required the full commission. But I think it shows, first of all, that independent agencies aren't quite as insulated as we like to think that they are. Also, that politics is very present. It is this blood sport. And we also have a report from the Blue Ribbon Commission, which President Obama also requested to be appointed, that suggests that we need an entirely new entity responsible for disposal of our nuclear waste and a completely new site selection regime to be put in place. So there's still a lot to keep an eye on with the politics as well as with the law. So thank you very much.
All right, batting cleanup. It's Friday afternoon, it's a sunny day, it's 70 degrees in late February, and you are here to think about and discuss administrative law. Wow. Justice Scalia would be ever so pleased. In fact, I won't quote his somewhat politically incorrect saying about the study and consideration of administrative law, but you can Google it if you want, and I think you're definitely earning your administrative law geek badges by being here at 1:42 on a Friday afternoon. Let me also add by way of introduction that I considered opening by singing the Norma Desmond number from Sunset Boulevard, It's As If We Never Said Goodbye, substituting for Hog Eye, the spotlight guy Jancy Haywood, who was here even when I was a law student back in the early 90s, but I thought that would be inappropriate and too theatrical. So let me say instead that I'm pleased to be here. I'm genuinely complimented to have been invited to participate in this symposium. I genuinely enjoyed the time I spent here at Duke Law School when I was, if not in your chairs, alas, our chairs were not so nice and comfortable and ergonomically correct. There were cheap-ass plastic things that were rotating around, but the same room, not the same chairs, and that I really treasured my time here and got a great legal education. So let me start by saying that, and now let me bore you into submission by talking about cooperative federalism, the new formalism, and the separation of powers revisited, free enterprise fund, and the problem of presidential oversight of state governments enforcing federal law. So let me start with a baseline proposition, and that is formalism is back in vogue, sort of like Madonna. The Roberts Court has consistently embraced formalist reasoning in its major separation of powers decisions and has reached formalist outcomes as well. The Free Enterprise Fund v. PCAOB, you'll often hear that called peekaboo, unless you're really dyslexic and add some letters. I can't get peekaboo out of PCAOB, so I will say PCAOB, but peekaboo is often the sort of mono or dual syllabic version of that, the Public Corporation Accounting Oversight Board. Stern v. Marshall and New Process Steel also follow this pattern of formalist reasoning and formalist outcomes. And let me say just sort of briefly that formalism generally eschews balancing of cost and benefits of novel administrative structures in favor of drawing and enforcing categorical lines based on a system of typology. Question 1, what is the nature of the task? And question 2, is the task being performed by the branch of the federal government assigned to that role under the Constitution? Article 1, the Congress, legislative power. Article 2, the executive, the president, executive power. Article 3, the judiciary, judicial power. And each section 1 of Article 1, section 1 of Article 2, section 1 of Article 3 say that power not might be vested, could be vested, in an ideal world, mostly would be vested. It simply says it is vested. The legislative power is vested in the Congress, executive power is vested in the office of the president, and judicial power is vested in the Supreme Court and in inferior courts if Congress deigns to establish them. And now, prior to the Roberts Court, the Rehnquist Court actually issued a number of very prominent functionalist decisions, perhaps most famously Morrison v. Olson, involving the independent counsel provisions of the Ethics in Government Act, and Mistretta v. United States, which sustained judicial participation on the United States Sentencing Commission. Now, my claim today is that this new formalism could have interesting implications for cooperative federalism structures, and particularly for structures that formally involve state enforcement of federal law. If the court really means what it has been saying about the centrality of presidential oversight of all aspects of federal law execution, then the use of state government officials to enforce federal statutory schemes arguably violates the separation of powers doctrine by cutting the president out of the picture. To be clear, I do not claim this result is inescapable, nor do I make any normative claims about the desirability or utility of the unitary executive theory that seems to be driving the conservative majority on the U.S. Supreme Court in its major recent separation of powers cases. That said, taken to its logical conclusion, a free enterprise fund would seem to require that cooperative federalism programs integrate meaningful and direct powers of presidential control over the state government's execution of federal law. All right. It might be useful and helpful to begin by defining a few terms. Clarity is generally, though not always, a virtue in legal argument. First, by formalism, power quotes, I mean a general approach to separation of powers questions that does not consider the utility or benefits of a novel structure that reassigns powers either among the three branches of the federal government or that delegates those powers entirely outside the federal government, i.e., perhaps to the states, to local governments, or even to private entities. For example, Congress could not vest the final interpretation of the Constitution, treaties, and laws of the United States in the State Supreme Court of Montana. Doing so would violate the vesting clause of Article 3, Section 1. The federal judicial power shall, not may or could, shall be vested in the federal courts. So too, Congress could not itself execute laws or do so indirectly by appointing executive officers directly. Execution of the laws is an executive branch task, period, full stop. See INS v. Chadha, see Boucher v. Siner. Scholars and courts tend to speak of encroachment and aggrandizement as central concerns in separation of powers analysis. In general, formalists tolerate far less encroachment than do functionalists, and in general, formalists care far less about the potential benefits to be obtained from novel administrative functions and schemes than do functionalists. To be clear, formalists do consider reasons from time to time. We're not mindless, and functionalists do not completely ignore structural limitations implicit or expressed in the Constitution itself. It's more a matter of the degree of emphasis and the relative weights accorded to these considerations. In point of fact, some fairly prominent administrative law scholars, including Liz McGill at Virginia and Ed Rubin at Vanderbilt, have criticized the whole dichotomy between formalism and functionalism. And I would cheerfully acknowledge the relevance and utility and importance of these criticisms. That said, even if formalism and functionalism are not the best potential framing devices for thinking about separation of powers questions or framing them, the Supreme Court itself, both in the majority opinions and in the dissents, continues to deploy this dichotomy. So I think we really can't simply ignore it, even if there might be a better way to think about relative institutional comparative competences. All right. Next, we might ask, what is cooperative federalism? Cooperative federalism involves joint state-federal programs in which the federal government enlists the states to operationalize federal statutory programs. They actually began in a serious sort of way going back in the 1920s with the U.S. Department of Agriculture and the Forest Service enlisting states to help in the management of federal forest lands. However, it wasn't until the 1960s and the 1970s that cooperative federalism programs really exploded with major environmental laws, the OSHA Act, most recently, for example, the Patient Protection and Affordable Care Act. All of these major federal enactments provide salient examples of cooperative federalism in action. And strictly speaking, in many cases, a state must enact a state law that promises to enforce standards no less demanding than otherwise applicable federal standards, and the federal government itself must approve a state's application for primacy status. Some cooperative federalism programs, at least nominally, involve delegations to states of enforcement of federal programs. The Safe Water Drinking Act, for example, provides that states may take over partial aspects of the program rather than the complete program. So it's a more limited form of devolution. But in general, if a state obtains primacy status, it is completely responsible for the enforcement of that federal program within that jurisdiction. When a state has obtained primacy status, it enforces state laws and regulations that essentially mirror those established by the relevant federal agency. The state agency is subject to auditing and reporting programs. The federal agency, in theory, can suspend state primacy status or sometimes even overfile a state agency if it thinks the state agency is under enforcing in a particular instance. In terms of being able to direct a state agency enforcing a program mandated by federal law, federal oversight is in many respects quite limited. In general, the federal government cannot hire, fire, or directly superintend state enforcement of federal laws. The government, and the president if you prefer, has the power to displace rather than the power to direct state enforcement of federal law under these programs. So, to come to the crux of my argument, if a two-tiered form of good cause removal unduly insulated a federal, power quotes, italicized, bolded, agency from sufficient presidential control and oversight, how can the wholesale exportation of federal law enforcement to the states pass constitutional muster? Presidential forms of control over the PCAOB, aka peekaboo, I'll go there, sigh, were more direct and more meaningful than EPA's control of the Mississippi Department of Environmental Quality. Moreover, the design has the effect of maximizing congressional influence over federal law enforcement. There is no national agency or officer able to set and enforce priorities directly. Congress generally provides grant funding to states to enforce these federal laws. They essentially pay for the state agency rather than giving the resources to the EPA or to the Federal OSHA Administration, which means in practice that agencies at the state level effectively answer to Congress as much as to the president. The state agencies, as several legal scholars, including Maggie Lemos, and also including Jessica Bullman-Posen, Heather Gerken, and David Super, have noted often engage in various forms of rearguard actions, which Bullman-Posen and Gerken style uncooperative federalism, a clever turn of phrase, I'll borrow it, and use discretion to thwart or even openly oppose federal regulatory goals. To quote a line in a Scalia dissent, the states ride with the cops but cheer for the robbers, or to sort of replace it, the polluters. So, state agencies and officials also have different constituencies than their federal counterparts and different objectives than the president or the administration. So if direct presidential control of the execution of federal law is essential to the separation of powers doctrine, then cooperative federalism should be no less objectionable than unduly insulated federal bureaucrats and entities like the PCAOB. And just a brief recitation of what was going on in Free Enterprise Fund. The SEC was by stipulation, the Securities and Exchange Commission was by stipulation said to have members who served subject only to good cause removal. Although interestingly, that was a stipulation in the briefs. It's actually not in the Organic Securities and Exchange Act, but the majority assumed that the president could remove a sitting SEC commissioner only for good cause before his or her term expired. In turn, the PCAOB could be removed by the SEC only for good cause, so that you had a double-barreled or a two-tiered good cause removal system, which Chief Justice Roberts in Free Enterprise Fund, writing for the majority, said transgressed the separation of powers by unduly limiting the president's direct ability to control and direct the operations of the PCAOB. To solve this, they simply struck out the good cause protection for the PCAOB members so that the SEC could remove them at will. All right. Now, having made the argument, and without belaboring the point, let me add that there are some obvious responses to my argument that I think are quite credible. First, one could use a formalistic lens to argue that states are merely enforcing their own state laws, so that presidential control really isn't implicated at all in cooperative federalism schemes. Now, this requires relying on a little more than a little willful blindness, given the scope of the federal shadow in which cooperative federalism programs operate. As a general matter, the federal government does not fund, audit, or require reporting from states regarding their enforcement of purely local laws. Also, if Congress used cooperative federalism more aggressively, it could theoretically export defense, foreign relations, and enforcement of federal laws more generally to the states through voluntary cooperative federalism programs, leaving relatively little executive power directly in federal executive hands. Given the scope of the federal overhang, I think it unlikely that the Roberts Court would find that states are simply enforcing state law and wave off the problem if they were to reach it. A more promising response would be to hold that existing federal oversight programs satisfy the imperatives of the separation of powers doctrine. This argument is credible and might prove successful were free enterprise fund deployed to attack, in a general sort of way, cooperative federalism programs. The problem, however, is that oversight programs in place are almost always backwards, not forwards looking. They involve the power to remove or displace state agencies enforcing federal law, not to direct or supervise them directly, which, as if you read Free Enterprise Fund broadly, would be required. Free Enterprise Fund says the power to supervise and remove executive officers is central to the unitary executive created under Article 2, Section 1, and to facilitating the faithful execution function. The ability to displace is simply not the same thing as the power to direct. Moreover, limitations on the displacement power make it a poor substitute for direct presidential oversight of a federal entity. Overfiling, for example, is often limited by statute and subject to judicial oversight. Moreover, it can take literally months, if not years, to pull primacy from a state agency. Congress's structure for these programs also makes pulling the plug very difficult, perhaps impossible. EPA and OSHA simply could not step into a single state's shoes in terms of permitting and enforcement actions without vastly enhanced staff, financial resources, and even expertise, which the federal agencies presently lack. If you don't perform a particular task, you might not really have a good idea about how to go about doing it. So the power to pull the plug on a bad state agency, a rogue state agency, is, I think, really more illusory than real. Even so, and notwithstanding these counter-arguments to the counter-argument, the Supreme Court could call the imperfect control mechanisms good enough for government work and move on. Alternatively, the Supreme Court could simply refuse to answer or address the question of free enterprise funds' relevance to cooperative federalism programs. Prince and Lujan had language extolling the unitary executive theory. Scholars noticed it, wrote about it, said, wow, does this mean ... And as we stand here, 20 years later in one case and almost 20 years later in the other, the Supreme Court has never followed up on its dicta. The Supreme Court, in this case, could decline to connect the dots, leaving free enterprise fund in place, but never addressing precisely how or whether it applies to cooperative federalism programs. Finally, I don't think that creating more direct forms of presidential control or oversight would work very well. That would be another potential solution. Give the EPA and the president the ability to direct and control state officers who are controlling or engaging in the enforcement of federal programs. The kind of control necessary to meet the separation of powers concerns effectively would do great violence to principles of federalism protected under the 10th Amendment. It's inconceivable that the president could enjoy the power to fire or hire a state director of environmental quality or a state attorney general, for example. Now, I should note that Stephen Calabresi and Cy Prakash offer direct presidential control of state officers as a solution to the problem of attenuated control of state government officers performing federal functions. But I think Evan Kaminker has the better argument when he says that that is just unthinkable if we're committed to treating the states as having a kind of dual sovereign role. Cooperative federalism rests on the notion that states volunteer to enforce federal laws and cannot be forced to undertake these tasks. The kinds of direct federal oversight that would meet the SOP concerns would undermine the rationale of dicta and Prince that suggested that voluntary enforcement of federal law did not violate the anti-commandeering principles of the 10th Amendment. It would be possible to meet the separation of powers objections with greater statutory oversight provisions, but again, the 10th Amendment problem would be enhanced, I think, in direct relation to the reduction in the scope of the separation of powers problem. Literally, as one problem was resolved, the other problem would be increased. So in conclusion, if the Free Enterprise Fund Court meant what it said, cooperative federal programs stand on relatively thin constitutional ice. Moreover, it's difficult to square the broad vision of direct presidential oversight and control, ostensibly mandated by Article 2 itself, with the notion that Congress is free to bypass the president at will by exporting the enforcement of major federal laws to the states. I think that if cooperative federalism is to survive Free Enterprise Fund, it's going to require a little bit of fancy footwork or willful blindness on the part of the court. And lastly, just to come clean, I think if you ask in policy terms whether cooperative federalism is a good thing, this phenomenon of uncooperative federalism ought to be deeply disturbing to all of us. Whether your drinking water is safe, whether your air is fit to breathe, whether your waters are polluted, shouldn't be a function of whether you live in Jefferson County, Alabama, or Tuscaloosa County, Alabama, or in the state of California. Process and substance bleed over. And so to have all of these wonderful federal programs meant to ensure health, safety, and welfare, environmental protection, all of this, but then to sort of strand these programs by investing enforcement in states that are engaged in a de facto race to the bottom, suggests to me that, you know, if you have lemons, if you don't like free enterprise fund, there might be some benefits in terms of actually securing some of these federal goals more effectively by holding states to tighter leashes under the rubric of this unitary executive theory. And again, I'm not saying the court will go there. The court can do as it pleases. But it seems to me that cooperative federalism deserves and perhaps requires more careful scrutiny and contestation than it's received so far, at least if we think these environmental statutes, these federal labor statutes, these worker protection statutes protect important rights that ought to be uniform, so that crossing a state line doesn't mean drinking filthy water or breathing dirty air. Why don't I stop there? Thanks.
So thank you, all three of you. That was great. We have either 15 or 30 minutes left, depending on how one defines our time. I'm told by the powers that be we could sneak to 30 minutes if we need to. But so before I open it up to questions from the audience, I just want to give you three a chance to ask each other questions or respond to things that have been said if you'd like to. You certainly don't have to.
So I just want to just convey a sentiment that I had while I was reading Professor Meazell's paper, where she was describing this long, drawn-out process that had to do with the Yucca Mountain case and the various interest groups wrangling and the president and the campaign, and this unfolding over years and years and years, and allowing for various kind of forces to, well, some come up and perhaps abate, and then other considerations to come in. And as I was thinking about that, I was thinking about the financial crisis, where everything, all this comes together in an explosive moment, and in 2 weeks, 3 weeks, how long? I think Lehman was under consideration for about 10 to 15 days max. So imagine all this energy kind of getting together and breaking the atom for this in these in just a very short amount of time and as an illustration of what I'm trying to say by having politicians taking these decisions. So I was thanks very much for this description. It was very lively and I really enjoyed it.
Thank you. Thank you.
I would say, too, that, if you're asking me should nuclear waste be stored or not stored based on whether Harry Reid increases his political contributions, I find that a little distressing. I mean, I think you're right to suggest that when Congress calls for formal adjudication, requires that an adjudication occur on the record after public hearing, that the primary objective ought to be getting the facts right. And there are facts, right? I mean, Quayle said facts are stupid things, but if you're trying to determine, whether a particular site is safe, and whether the transportation scheme and the protocols for all of that are going to protect the population, you want those facts to be determined correctly and not through the lens of politics. But it's sort of a larger theme that we've seen all day, I think, is this inherent conflict in administrative law between a desire to get things right, to bring expertise to bear, and at the same time to leave room for democratic politics to effectively function. But in the case of storing nuclear waste, one vote for getting the facts right.
Hear, hear. So I'd like to ask a question of all three of you, I think, before I allow anyone else to, and that is kind of building on this question of democratic politics. I wonder whether you have a theory about why we are getting increasing dispersions of power in the ad law field. Reading your three papers, various possibilities kind of jump out. One is just, the need for more hands on deck, and so I think that helps explain cooperative federalism. There are things that it would be hard for the feds to do by themselves. There are things that it may be hard for one agency to do, and so having more agencies, or including the states, just, gets more people working. There are some suggestions that maybe dispersing power helps build a consensus around the bill, that we can get more people who are happy with what the bill is doing, and so you can pass the bill. There are suggestions of accountability dodging, right, in the dispersions of power. And then I just had to wonder in many of the stories that you all told whether it's just easier to add a new agency than to fiddle with one that already exists, because there are existing stakeholders. And so this is, I think, mostly a question for Emily and Stavros, but both of you give us this picture of this push toward more dispersion, and I wonder if you have a theory of the politics behind it.
Well, certainly with the Nuclear Regulatory Commission, I think it does have a very specific history. Initially, that agency was the Atomic Energy Commission, and it was responsible both for licensing and developing nuclear power and for setting policy with respect to it. And so as nuclear power generation became possible and was encouraged, there became a great concern that the NRC, or the AEC at the time, was completely captured by industry. It was basically both working with the industry to develop the potential for electricity and licensing it. And so there were significant safety and environmental concerns associated with that. And that really led Congress to splitting it up. So there, I think there was a sense of having greater accountability and of dividing the expertise from the politics of it. This happened in the 1970s, and I go into some detail about it in the paper, but I think Congress was actually trying hard there to have an energy policy body, which became the Department of Energy, and then this special insulated expert licensing agency, which turned into the NRC. A little bit more generally, though, I think that sometimes having enhanced accountability isn't necessarily going to be the only reason that Congress does something like that. And one of the things that I think about in the context of dread risks, which of course nuclear is one, this idea that these are things that have catastrophic potential consequences that people are not very familiar with. I think there is a sense that if you impose complexity on the decision-making process, you're more likely to do it well. At least you slow down the deliberative components of the agency decision-making in a way that, that hopefully respects safety, which we care a lot about in the context of dread risks. It's also very politically appealing to say that you're really making sure that safety is going to be number one when we're talking about those dread risks. Of course, the problem with that is we may never get it done, which we've been seeing here too.
So I think you're absolutely right that it was consolidating regulators is just very, very hard to do, especially when regulators are really established. So we saw, in the countries where we saw consolidation of regulators, it was they were not regulators that had a very long history. There were regulatory entities that had been created 10 or 15 years ago, and then there were other bodies that preceded them. So there was this so change was very much part of what was going on. It was not an institution like the Securities and Exchange Commission, which was established in the 30s, merging with another one that was also established many decades ago. And of course, the proposed merger between the SEC and the CFTC didn't move forward in the Dodd-Frank Act. But then, with regard to your other point, it's very easy to understand what we're describing as the pendulum kind of swinging back, starting from an idea where we want democratic accountability and we want politics, and moving on to this idea of independence and expertise, and now we're going back to politics. But I don't actually think that this is what's going on. I think that we're seeing progress in a linear dimension, in the sense that we're trying new institutional designs that do not deny whatever we have learned from the past, but they're trying to combine them in new, more inventive ways. So I think I don't think that many politicians, even Dodd and Frank, would argue that there's some value in what the SEC is producing, and there's some value in what the Fed is doing by trying to get an understanding of what is a CDS and how does it all work and how are they all connected, and that we need someone like that to do it. But I think at least the fear is that if you just take the effort to understand what's going on, you just become too enmeshed into it. So on the one hand, so it's clear that you need someone, an expert, to do it, but it's not clear whether that expert has to be the ultimate decision maker. So once you produce the information, so what I see as kind of a development from this traditional idea of expertise is that the presumption that if you have all the information available to you, you will make the right decision. That is what's been challenged. That at that final step, you might need an additional decision maker.
Well, let me bite on the fleeing for the exits motif that you mentioned, the accountability argument. John Stender, who was Assistant Secretary of Labor for OSHA, 1975, 5 years after the OSHA Act passed, said in writing that Congress would never have enacted the OSHA Act if it hadn't included the state plan provisions. I think Congress designs these things to fail. They want to take credit for providing comprehensive protection without unduly compromising interests in their districts. And so my sense is they design these things to not work on the theory that there's the political benefit of saying, well, I've done something without having to actually own the negative economic consequences. So if you're in West Virginia, if you're Jay Rockefeller, you can say, well, I voted for all sorts of mining laws to protect miners from disasters of the sorts we've seen almost every year, I guess, for the last 4 or 5 years. And then when something goes bad, you can say, well, West Virginia's mining authority ought to do better. Their mining regulator ought to do better. In terms of this crisis with sovereign debt, look at Greece and look at Italy. Who's running those countries? Not the regular politicians. They brought in technocrats. They're going to come in, take the hard votes to cut pensions and salaries and jobs, wrenching decisions that are going to ruin people's lives, and then they'll be pushed aside, and the regular folks will come back to the table. We talked about the non-delegation doctrine earlier. I mean, I think there's a point of nexus there, and I think Catherine said that, you know, the choice isn't between having Congress write better laws, it's between having Congress write garbage that the president then makes some meaning out of, or having no federal laws. And even Justice Scalia in American Trucking, when faced, he looked into the abyss, sort of the Nietzschean abyss, he looked in and he didn't dive in. Okay? He looked at no abyss today, thanks. He stepped back and basically said the Clean Air Act, which doesn't really have a lot of specificity regarding the cost benefit between clean air and cost, was good enough for government work, and that it was a sufficiently channelized delegation of authority to Congress. I do think that that's something we could contest a little bit. We accept that kind of reflexively, and it may well be true, but look at the United Kingdom and their parliament. Parliament enacts much more specific statutes, does so more reliably. Even secondary legislation, regulations, can be put through Parliament. Now, there's obviously an important structural difference, right? There's no separation of executive and legislative power, no Senate filibustering Tony Blair or David Cameron, and there's a danger of tyranny associated with putting executive and legislative power into the same hands and giving a majority of the House of Commons. The House of Commons could wake up tomorrow and say all left-handed people shall be put to death, and the British courts would not stand in the way of that law. But if I were to conjure some British lawyers and say, well, aren't you terrified of tyranny? Don't you need structural separation that ties your government in knots? Oh, no. In fact, I took a class here with a guy named P.S. Atiyah, a very well-regarded Oxford prof, and I was your system sucks, dude. And he's like, our system does not suck. And I'm like, well, what protects you from tyranny? He's like, sir, we have 400 years of liberty. That is what protects us from government tyranny. And by and large, if you took polling data in the UK, you would find that there's generally much more reflexive trust and support in their government, and they have a government structure that's far more efficient and gets things done more effectively, more cleanly. You wouldn't have the Patient Protection and Healthcare Act, Affordable Health Care Act in the UK. You'd have a much more rational piece of legislation. But our framers were terrified of this possibility of tyranny and designed a system that already was unwieldy, and then through constitutional custom, with things like the seniority system, the committee system, the filibuster, have rendered the system even more Byzantine and impossible to run. So there are systems in which governance is effective, expertise is brought to bear, legislators actually are responsible for policies. There is such a world, but I'm not sure that our present system can deliver that because of the incentives. If the incentive is to win, then, and winning can be best achieved by humiliating the opposition. There's not a lot of incentive for, what is the incentive for John Boehner or Mitch McConnell, or conversely for Nancy Pelosi or Harry Reid when W was president, to do things that make the president look good? Zippo. And that's why we're in deadlock, I think. But, we really ought to expect more of our politicians, and I'm not calling for a constitutional convention, and I'm not crazy, right? But it does seem to me that our structure leads us to devolve power in ways which are suboptimal and which go to these questions of accountability. The great thing about a parliamentary system is that it features direct accountability and broad authority. And the politicians are ultimately accountable, and you have to sort of trust in elections and in traditions and in culture to provide a meaningful check. We've gone a different route. And, if you talk to someone from Australia or Ireland or France, they think our system is nuts. I'm not saying that, especially on tape, never get confirmed anything, but I do think our system has definite operational costs that really make accountability and accountability avoidance from a political economy point of view a desirable course of action in a way that's unfortunate.
That would be kind of a depressing note to end on. Do we have any questions from the audience?
I had a question for you, Ron. You said that full cooperative federalism would require willful blindness to the recent sort of resurgence of formalism that we saw in Peekaboo and in Stern versus Marshall. And I wondered whether that's really true, because if we think about how pragmatic the decisions were, in Peekaboo, Robert says double for cause not okay, but he's implicitly accepting single for cause, leaving a single error on the table, upholding the permissibility of independent agencies. And then in Stern versus Marshall, he seems to go out of his way to say bankruptcy court's not okay, but it's because it's not the traditional administrative agency context. We're not dealing with a complex regulatory regime. We're not dealing with administrative agency here. So he seems to leave that on the table. So it seems as if we're kind of slicing out these narrow places in which they can use formalist reasoning, but being very pragmatic about leaving other things untouched. And I wonder why that pragmatism wouldn't spill over into the cooperative federalism reasoning.
All good points, and I'll grant all of it. In fact, using that lens, option B, saying that the existing forms of control like auditing and funding and the ultimate ability, in theory at least, to pull authority would be enough to satisfy the separation of powers. That would be consistent with what you're suggesting. On the other hand, the broad language about the critical importance of presidential control. He quotes President Truman saying, I have to beg people to do what they ought to do. And he says, no, the president is not a pleader-in-chief, he's an executive-in-chief. There's very broad language about the centrality and importance of direct presidential oversight of the execution of the law. So it depends, and there's also Humphrey's executor lurking, right? I mean, what I would say in response to the single-barreled, to the single-tier good cause is Roberts is a fairly incremental, minimalist judge. Humphrey's executor is there. To resile from Humphrey's executor would have been a much more radical step in the law. And I may be wrong, and I'm not saying I'm certain this is going to be the path the court takes, but it does seem to me you could connect the dots in these ways. But I would agree with you wholeheartedly that the court need not connect the dots in this way, and that they could simply focus on levels of oversight and control. They still, though, do generally involve retrospective rather than active ability to see that laws are faithfully executed and to actually implement the law. So I don't know. I doubt they mean what they say. I'll just be honest with you about that. But it seems to me they could.
I have two questions that relate to Professor Meazell's piece. The first of which is, it seemed to me in your paper like you were very careful not to establish any kind of hierarchy, and yet it also seemed to me, in light of your preference for congressional intent, and perhaps this is just because of the Yucca Mountain context, that independent agencies would more often be winning these battles because of their isolation from the presidency. So I was wondering if you could speak to that first. And then second, I also thought it was interesting, the contrast in terms of the deference dilemma that you're talking about as opposed to the one that we talk about most often in admin law, which is the deference dilemma between the courts and the agency. And it almost seems to me just commonsensically like having these conflicts between the two agencies where we're choosing to whom we should defer, that's going to take the courts a little bit out of the picture, which is perhaps preferential, because the court's unlikely, it seems to me, to say, both of you are wrong, and we're going to insert our own independent judgment in here. Instead, they're going to be forced to choose between these two agencies, perhaps returning more to the promise of Chevron, that being that the agencies would more often get deference and things would be a little more consistent. So I'm just wondering if you'd speak to those two thoughts.
Sure. Yes, you're right. In the paper, I try very hard not to put any of those factors higher than the other. But I do think that to the extent those features of independence include a congressional intent to further a particular expertise, that you might have a situation where they sort of naturally pile up on each other. So I think that's insightful of you to notice that, and then that is a possibility with what I suggest, which may be a critique of it as well. With respect to the deference issue, and here we might talk a little bit more about the particular issue, but so first of all, I do think that it's important to be clear that I'm thinking about how, if you have two agencies saying they have a reason for deference, what would a court do to choose? And I think that this is a place where sort of the passive virtues of courts and the idea that we would prefer them not to make policy-driven choices, even though we know that there are those heuristics and biases going on. That's another of the reasons that I think kind of trying to come back to congressional intent is at least helpful. It gives sort of an independent analysis for the court to go about the process of choosing which approach to take. And there, the way I envision it is once that happens, once a court says, okay, we think in the Yucca Mountain that the NRC is the one that Congress means us to look at first, at least in terms of deference, then I would envision the same scheme that you've learned about in administrative law coming into play. So that's where you do the Chevron analysis. That's where you do the arbitrary and capricious analysis. You would still be looking at whether the NRC rationally justified its decision, for example, to deny the motion to withdraw. So I don't mean to suggest that we should take any of that out, just that there's sort of, this is kind of analogous to a Chevron step 0 type issue, which is where do you go in the first place?
All right. I think we can call this a day. Thank you so much. This was really
So thank you to all of you for being here. I was remiss earlier and failed to thank the person to whom we owe the most thanks, which is Alex Costanza, without whom today would not have happened at all. So please join me in thanking Alex. And then I just wanted to thank all of you again for coming, and once again thank our moderators and our panelists for coming all the way here and for presenting such interesting topics and papers. And for making today such an exciting day. So thank you again.
Produced by Duke University, online at duke.edu.